I think we're live on YouTube now.
Just give another 5 seconds and just start setting up.
Sure.
Done. You can start.
Thanks, Kisha. Good evening, everyone. Thank you again for making the time to come for this book discussion. We're discussing the book titled Competition Law in South Asia, Policy Diffusion and Transfer. I have with me here today Dr. Amber, who is in fact the author of this book, and Professor Rahul Singh from National Law School of India University, who teaches competition law. My name is Manjushri. I'm a senior resident fellow at Vidhi Center for Legal Policy, and I primarily work on competition law. And welcome to what promises to be a very, very exciting discussion on why competition policy and why South Asian competition policy. And I think Dr. Durr has done a wonderful job with her book that takes us through in detail as to what are the socio-economic and political peculiarities of South Asia, and how should competition law respond and adapt to that sort of an environment. So without further ado, I will allow Dr. Durr to take the stage and take us through, give us a brief overview of the book. And in segment 2, we will move on to a moderated discussion on some of the important themes identified in this book. And in the last segment, we are going to talk about what this means for digital markets in South Asia. How should we look to respond to competition problems that are emerging in digital markets? And if time permits, I'm happy to take in any questions from our audience today. So over to you, Amber.
Thank you, Manjushri, and thank you, Vidhi, for hosting this webinar. It is a real pleasure to be here. Thank you, Professor Rahul Singh, for being here, for agreeing to be a discussant. I'm very much looking forward to this conversation, and I hope that it is enjoyable also for our audience. So a brief introduction of the book. I like to think of it as a story about competition law in South Asia, told in 9 chapters. So the first chapter is quite theoretical. I set up the framework for analysis, the core argument being that the process and the institutions through which South Asian countries have adopted competition laws have had a significant impact on the subsequent implementation of these laws in the countries also. This was quite a new study, a new idea, because mostly competition laws are looked at from an economic perspective, their economic impact, their economic rationale. What we don't see is the political economy aspect of these laws, how the legal institutions and the political institutions of the countries come together to shape these laws, and how then that affects enforcement. So the first chapter then draws upon development economics. It draws upon the literature of political science and, literature of political science, diffusion and transfer, which of course is the part of the title of the book, and also upon comparative law and the literature on legal transplants to develop this integrated framework of analysis, which connects the adoption phase with the enforcement phase. The second chapter sets the scene. It travels, I like to think of it as mentally traveling to each of the 8 South Asian countries, which includes India, Pakistan, Bangladesh, Nepal, Sri Lanka, Maldives, and also Bhutan, which didn't have a competition law, but 2 competition policies, and Afghanistan, which despite all its political issues also has a draft competition law. So I went to each I mentally went to each of the 8 countries, and I set the scene for their process for adoption and how it started. Chapter 3 looks at India and Pakistan in more detail, because these are the 2 countries that have gone from adoption to implementation. So that was quite a unique case study that I could do in the South Asian context, and also comparing the 2 to bring out the differences which may not have been obvious had we only been looking at one country. The next few chapters are devoted pretty much to the Indian-Pakistani experience. I'm comparing various aspects of the enforcement paradigm and how it was influenced by the adoption. So for instance, as an overview of the enforcement over the last 10 to 12 years, the case law has been analyzed and data derived from the decisions of the competition enforcement authorities have been compared to create greater insight. So I'm looking at, what kind of penal practices they've adopted, whether they've relied on foreign precedent, to what extent have they relied on foreign precedent, what have their interactions been with their pre-existing courts in the countries, has that interaction been supportive, has it created more obstacles, and what are the factors that have influenced these relationships. In chapter 8, I go back to the South Asian context, and I take the learning from India and Pakistan, take it to the South Asian context to see how the different countries can learn from it. And the most interesting thing that I discovered in this analysis was that even if things don't look like they're going to plan, so for instance, as I said, the 6 other South Asian countries are not enforcing competition laws, there is a great moment of opportunity in what I call the hiatus stage. So even when the adoption, the enforcement is not taking place, the countries can use that period to create greater awareness. And it turns out that certain countries are, of course, engaging in that exercise as well. Foremost, I think, was Bangladesh, which even though established a competition authority, was not enforcing the law at all, but was using its platform to create more awareness about competition issues. The 9th chapter goes beyond this analysis to see what can be done to bridge the gap between enforcement and adoption. What role can the multilateral agencies, which have played a very dominant role in the adoption of competition laws throughout South Asian countries, what role can they play in the adoption process to make these laws more meaningful for us in our South Asian context? So for instance, linking them more directly to our development imperative. All South Asian countries have development challenges, income inequality challenges, poverty challenges. How can we harness the potential of competition laws to help us with these challenges? Of course, the digital era that we've entered in the last few years, and of course, India is, and Pakistan as well, has made great strides, as well as other South Asian countries have really sort of embrace the digital revolution, how the potential in that digital revolution can be harnessed also to support our competition enforcement and to really for our countries to emerge as more competitive economically. So it's a long story, but one that is of interest to all of us and is likely to have an impact on all our lives, not just some technical technocrats sitting in competition agencies in the capitals of our countries, but something that should be of interest to each one of us.
Thank you, Amber. I mean, I think that was fantastic. If that's the intention of the book, let me say that I managed to devour it in a week, and it was a fantastic read. And I'm hoping our audience will go back and do the same sometime over the course of the time. Rahul, if I may come to you, some brief introductory remarks and what you think about South Asian scholarship when it particularly comes to competition law and policy.
So first and foremost, thank you very much for having me here. I feel delighted as well as privileged because I think Amber and we have been speaking for a few years now. And I think one of the common points of our conversation used to be that how little there is in terms of comparative literature when we look at South Asia. When Indians go abroad, I suppose as students, they all become part of this student society called SALSA. Right? And that is the South Asian Law Students Association. And that's one interface that you have with students from other cultural contexts, particularly from South Asia. And I suppose the book is like a salsa for the South Asians, right? Which is to ensure that the scholarly gap is also filled in terms of the conversation. And I suppose what is also critical, because I also had a chance to read the book, and what's very critical to take away from it is that this is a starting point of a conversation. And this is a very great start, and hopefully there will be others who will respond to this start. Right? And there were two ideas which, although it's put in the first chapter, the theoretical context, and it captured my attention. The one on compatibility, right? And because, in many contexts, it's hard to figure out why laws come in And I saw the book says that in Pakistan, it was the push from the multilateral agency. And in Indian context, it appears as if it was a little more democratic, though one may also see the push from multilateral agencies here as well. So I thought, that to think about these kind of push and maybe the pull as well from a theoretical model, and to think about compatibility. And the second element which the theoretical model chapter puts, which captured my attention, was the idea of legitimacy. Right? And I thought both these ideas are not only useful for just competition law in South Asia. In that sense, I felt that the impact of the book could be greater. I mean, at least in commercial context, which both of us are involved in, but maybe all of us here are involved in. Not just competition law, perhaps maybe the corporate insolvency law process, perhaps maybe the company law, what is going on. And e-commerce is certainly one of those contexts where you see where laws are still being thought about, like data privacy. There seems to be a greater scope to understand these laws from both compatibility as well as legitimacy sort of models. So I thought the framework will fit not just for competition law, it's also futuristic in that sense that for many laws to come, which we have not seen yet right now, let's say data privacy, maybe one can think about data privacy from the perspective of compatibility and legitimacy. Like one obvious example would be, should you locate data nationally? Should it be globally? Right? And different models, one can think about what would be more appropriate for a particular country. But these are my key takeaways as a first thought, and I thought I must share with all of you. Thank you.
Thank you, Rahul. So, Amar, if I may sort of come back to you on, talking about what motivated you to write this book in the first place, because as Rahul also sort of put it, it's very rare that we come across, competition policy and law, or any sort of scholarship or commentary on that, specifically with the South Asian context, because it's assumed to have not originated here. So there is some sort of an understanding that we don't get to talk about it. So I just want to ask you, what were your motivations, when you were going into writing something like this? What has your experience been? And generally, I just want to understand from you, how receptive do you think South Asia has been to competition law and policy? I'm not talking again about success, but simply in terms of the readiness to receive competition law and policy as a legal transplant. Could you take us through that, please?
Sure. So I understand these are two separate questions. First, what motivated me? And secondly, how receptive have different South Asian countries and South Asia as a whole been to the introduction of competition laws? So my motivation was very personal. I think for me, most, research takes up so much of our time that if it's not a personal connection, it's almost harder to stay with it. I understood from a theoretical perspective that competition was almost like an economic democracy. It provided a level playing field to all businesses. There would be no bullying in the economic field if there was a good competition law and strong competition enforcement. There'd be no ganging up against smaller companies. So I think that inherent idea of justice, which competition law seemed to embody, really, really attracted me. And of course, coming from South Asia myself, I recognized that we need to encourage small businesses. We need to encourage entrepreneurship. So competition seemed like a really strong vehicle to bring that about. But I also noticed that two things that I noticed when I was practicing law in Pakistan. First, that people didn't understand competition, and to the extent that they did, they were kind of afraid of it. It was almost too technical to deal with. And that, of course, was a bit of a challenge for me. And I thought, okay, well, why are people not engaging with something that I understand to be a really, something that will create more fairness in society? Of course, later we'll find out that competition law doesn't necessarily create fairness, but this is a layman's view before I started my PhD. And I think of course, again, as Rahul pointed out, I was one of those salsa students back in my student days, and I had an inherent attraction towards India as well, and the Indian legal system. We also, use Indian precedents in Pakistan also. So I think there was an idea that there's something to learn from India. they're so similar, and yet they have a different competition experience. We have the same legal system. We've inherited the same legal system. Our court cultures are very similar. Our problems in the, of delay are very, very similar. So how can we learn from each other? So that was the initial idea, that you do comparative study of India and Pakistan, which was the core of my book, as I've mentioned earlier. South Asia then grew from that. Because I think as I was working in India and Pakistan, I became extremely curious about what's happening in the rest of these countries. And of course, there was an understanding that multilateral agencies are spending a lot of money taking competition laws to them. So what's happening? Nobody had any idea. It was completely obscure. So even when I was researching, I realized that there was no, the material I was finding were news items or primary legislation. I was not finding any analysis. So I think it was, if you will, a bit of an adventure in me going into the unknown territory, but always with the hope of creating a better economic, a level playing economic field, a better economic environment for our countries which are beset with economic challenges. So I think that was sort of the very personal, very emotional almost motivation for an economic idea. Then this very nicely brings me to your second question. Sorry, Manjushri, were you going to say?
No, I was just going to come to the second question myself again.
Yes, so I was nice segue to the second question.
Yeah.
How receptive did I find the countries? I think the countries' receptivity was directly proportional to its understanding. I think that's a very simple formula. India has a long tradition of setting up committees to study laws. And even the monopoly control ordinance, there've been, the Sachar committee, the Mahalanobis committee, there've been various committees over the years which have examined. So I think there was an understanding of what monopoly control was. There was an understanding of what India's economic landscape should look like. So when they engaged, when the WTO introduced the idea that every country should have there should be a sort of a global competition law, but then that idea was abandoned and the countries realized we better wisen up to this and we better start thinking about our own competition laws, otherwise there'll be one imposed on us. So I think India was ahead of the game in that sense, and they set up the Raghavan committee to start studying what kind of law was good for it. Having said that, the receptivity took a long time to build and develop. So it's all relative. If I say X country is better, it's very much better only in a relative sense. Pakistan didn't create this kind of space, and it very much adopted the law through an ordinance, which we understand in a South Asian context has a limited shelf life of about 4 months, same in India and Pakistan. And they said once the ordinance comes in, it will create its own space. And then we'll bring in the act. And once the the competition commission starts taking actions, people will get to know about it. So it was more that, that created and then let it create its space. So I think the receptivity in that sense was much lower because the awareness was much lower. But then we'll talk about enforcement later. So and I think we see this pattern across the board in all countries. So wherever there was more awareness, there was more receptivity. How well prepared the institutions of the country were to receive this law is a totally different story. And I think that we can develop that as we go further. Otherwise, I'll keep talking for too long.
No, not at all. So, that was actually very insightful to understand, because something that I'm going to come back to later is to precisely understand. So when we look at success of a legal transplant, as your book also makes the case, there are various other markers that we will sort of look at. So I'll just, come back to that quickly, just put up in there. I just want to move to Rahul right now. Rahul, so, when India started deliberating on the Competition Act 2002, through the Raghavan Committee, etc., what sort of motivations or considerations do you think the committee had in mind then? And because, and as Amber rightly put it, a country's economic considerations are not ever completely divorced from their political considerations. So do you think there's been a change in the way we try and understand or apply or understand the purpose of competition law entirely? Or do you think it's something that we're yet to have a lot of work done on?
So Manjushri, I think Amber has already alluded to this idea of why India even thought about Raghavan Committee. And this is early 2000, and Amber is right, and I fully agree with her. that the initial motivations were really response to the World Trade Organization. As you know, India was one of the founder members, 1995. In that sense, the political leadership had the foresight to be a founder member. You just have to compare it with China because they missed that bus. And by 2001, when China is negotiating, they had to give a lot of concessions to WTO, to an organization which India was already a member of. So compared to China, at least in 1995, the Indian political leadership seemed far ahead. And the motivation behind competition law was, as Amber said, that if you do not develop your state capacity, at least in that context, maybe institutional capacities, you will be stuck with an international trade organization, World Trade Organization, where your local lawyers might not have much knowledge about. In fact, if you see, the WTO, although it's partly dysfunctional right now, because there is no appellate body at WTO right now, but India lost a case just 20 days ago on the Information and Communication Technology segment, ICT. The panel report has gone against India, right? And you will hardly see Indian lawyers specializing in World Trade Organization law because the law didn't really take off. But one of the reasons why it didn't take off is because possibly you don't have a competition law interface at World Trade Organization. And having said that, and just to give a better context to the other part of your question, if you look at Raghavan, with all due respect to Mr. Raghavan, he's a bureaucrat. He's not an expert. Amber did mention about technocrats and how sometimes competition law is seen as a legitimate domain of technocrats. The people who have some expertise in competition policy in the committee, let's say Mr. Moolji and all, they are largely writing dissenting notes in the Raghavan committee report. So in that sense, if one looks at the report, it's obvious that it's a political document. And when I read Amber's book, I was thinking about Raghavan committee because it does seem like if your political leadership is on a particular, let's say, path, and they want to have a competition law, so they will just put a set of bureaucrats to come up with a set of laws. And it may not matter whether economists like Mulji might say, I think if I remember his dissent correctly, or it might be the other Mr. Mohan's dissent, but one of the two, they say that India does not need a competition law right now because the scale that the Indian entities have attained at this stage, it does not warrant, for instance, a merger control, right? And this is 2000. And therefore, they argue that, why are you even talking about competition law, which might, at least in the context of merger control, abuse of dominant position, might want to speak about controlling the size of the corporate. So therefore, to me, the Raghavan committee is most certainly a political document as Amber's book outlines, frankly. Right? It's like an emblematic case of application of political ideology to competition content. And therefore, insofar as the early 2000s and motivations are concerned, if one has to think about it charitably, I think the only way to justify is that the leadership had the foresight and they wanted to ensure that there is a state capacity, some internal capacity to appreciate what an antitrust law might look like, if at all World Trade Organization thinks about it.
Got it. Thank you for that, Rahul. And sort of coming back to Amber on the the same strand of questions. Again, as Rahul put it, the idea to adopt a competition law, at least in the early 2000s, was primarily politically motivated because there was a statement that India wanted to make to the world, perhaps, and that's what motivated us to even start thinking about the possibility of an antitrust regime in India. So, Amber, when you look at transplants that are not entirely motivated for the law itself, but there are external considerations that act upon whether or not a law is passed or whether it's instituted in a country. How have countries sort of generally responded to laws that haven't arisen due to, let's put it this way, like a sui generis demand, but something that's been imposed externally because of political pressures? And generally, when you're looking at a legal transplant, how do we define the success of a transplant? Because, as we tend to typically see, and as you acknowledge in your book as well, there is really no need to reinvent the wheel every time we're trying, we are in crossroads about what to do about a particular problem. If there is a solution that has worked somewhere else, there is at least merit in sitting and thinking about whether that will work in our country too. But whether or not those are, we are addressing the same problems are a completely different question, but there is definitely merit in trying to borrow it. But when we are sort of doing this borrowing exercise, and when we are trying to understand how that borrowing is played out, how does one go about understanding the success of such a transplant? Would you have some markers in mind that one should typically look out for?
Yes, absolutely. I think this was a question that preoccupied me extensively. And Rahul has already, very sort of, I think with great insight has recognized the ideas of compatibility and legitimacy, which were very much my guiding beacons in this study. But so starting with the point that transplants are necessary and good. They're not bad things. I think this idea that somehow we should never borrow from anywhere is flawed, because we've borrowed always. Borrowing borrowing of laws is a reality which cannot be denied. When it comes to economic laws, there has been a very strong strand rather of literature which says that they're almost like a technology. It's almost like buying an iPhone and charging it somewhere. You can plug it in whatever socket, it will work. It will charge exactly like it does. I think those of us who've been sort of dealing with different voltage systems across the world know that that's actually quite a naive statement. That also depends on the electric current going through your walls, and you can't just charge it and plug it in. And sometimes you need adapters, quite literally. And I think that's exactly the story with legal transplants as well, that whilst it's a good idea to transplant, it's good to look to others and see what other countries are doing, especially countries that are similarly situated to you. You can't just adopt and borrow without what we in the diffusion literature, policy transfer literature, we would call it socialization, without adaptation, without contextualization. In my book, I also refer to Indianization, which we are not talking about the quality of the product that emerges from it. That's a separate question, but we're talking about the appropriateness or even whether that product will be understood in the context for which it is intended. For instance, what language will it be written? So I think this process takes place. Again, the development economics literature was very was very interesting in this regard, because they said, yes, you can borrow a blueprint, but the blueprint then has to be adopted in light of the knowledge and understanding that is tacit in the adopting country context. So how do you do that? How do you adapt? You adapt it through bottom-up processes. And what are bottom-up processes? For instance, the Raghavan Committee, politically motivated as it may have been, is really unique in the South Asian context, because it was probably the only government-led, government-empowered committee that spent 2 years at least creating awareness about the law, creating a sort of language around it to even have a conversation about the law, which led to, of course, the law being challenged immediately after it was enacted, but even that challenge is a positive thing. So those are the processes that then bring up that knowledge of stakeholders. And, of course, then the parliamentary enactment process has a further layer of discussion through the standing committees, and that's how that knowledge is. There's a feedback loop created between the society and the law. Speaking of the benchmarks of success, then how do you decide whether the law is successful or not? When I looked at the literature, legal transplant literature, some of them simply said, oh, if it's not rejected, it's okay. So I really had to unpack these things. What does it mean it's not rejected? And I decided to focus on two factors, which I think are very great signs of success, and they both relate to the extent of compatibility and legitimacy of the law. The first is, to what extent is the law understood, applied, and utilized in a given country? Are people using it, or is it simply lying there? and again, that was the argument was that the more compatible the law is, the more legitimacy it has in a context, the more likely it is to be understood, applied, and utilized. The second part of the success benchmark of success was what kind of interaction does the adopted law enjoy with the pre-existing legal context in which it is inserted? So what is its relationship with the courts? Are the courts receptive? Are the courts engaging, or are the courts blocking? And those two, so I think really those two sides, to what extent are the stakeholders engaging with it? Are they taking it up? Are they filing complaints? For instance, under competition law, we saw in India that there was a huge spate of frivolous complaints in the first few years of its operations. To my mind, even that is good. Even that creates awareness. What is more dangerous is if there's no uptake. And we did see that in Pakistan, where we had a lot of suo motu notices in the early years. So there was no uptake from the society. But the interaction with the courts, again, we saw that doesn't mean that the law should never be challenged before the courts. I think all challenges are good because they create a dialogue.
Yeah.
But what was dangerous is when the law is simply not taken up in that challenge, or there's a restraining order and it's just put to one side. So I hope that answers your question, but I think to me, both those were stemming from the extent of compatibility and legitimacy. And I just want to emphasize that all these discussions are relative. It's not to say that some law was perfectly compatible or perfectly legitimate, but just to say that it was a little bit more compatible than another law, or a little bit more compatible than legitimate than it was in another country.
Right. No, that absolutely. I think, especially the bit on courts, I personally enjoyed reading, because there's much to learn in India just in terms of, what happens to a case after it's heard by the CCI. There are several steps involved before there is a final decision on that regard, something on which even private enforcement in India, for instance, rests on, which we haven't seen a lot on, nothing actually on private enforcement. So definitely, I think how the court interact is a very important marker. And Rahul, I'd actually like to turn to you on exactly on that point. How receptive do you think Indian courts have been to our competition law? Because, there are problems that are intrinsic to the way India organizes its tribunals, but there are problems that emanate specifically perhaps because we don't have a specialized competition tribunal. The compact was abolished and all cases now move to the NCLAT as a matter of appeal right from the CCI. What sort of an appellate situation would you envisage to ensure speedy disposal of cases? That's part one. And part two is just to ensure that competition matters are also heard before members with expertise. Do you think there is a need for reorganization in terms of how we conceptualize our tribunals and courts, for that matter, for their interaction with specialized and expert regulators like the Competition Commission of India?
So, all very significant questions, but if I can start off from the data points that you just mentioned, at least just based on data, it looks like India is doing really well, because in terms of, let's say, contentious cases, commission, as you are aware, but for the benefit of our audience, around 800 cases, that's what they say. And for similarly merger control, you have a comparable 800 number. That's 1,600 cases in around 12 years or so, give or take, because merger control started slightly later. I don't want to spend time on those nuances. But in terms of data, it looks like commission has ample cases, right? And then, as you know, it all goes to, many of them go in appeal to now NCLAT, and there was a specialized competition appellate tribunal. So I think, Manjushri, I think much is made out of the absence of the competition appellate tribunal and this presence of this so-called national company law appellate tribunal. But we know that, as Amber, in fact, in her book also talks about her own experiences and the way she was strategizing, should she appeal at the High Court? Right? I might get the names inaccurately, but Lahore versus Islamabad High Court vis-a-vis Supreme Court. So as you know, many people in India similarly strategize that while the case might be appealable to the specialized appellate tribunal, should they also, in addition, challenge in maybe Delhi, Bombay? And several cases are challenged on those constitutional sort of judicial review grounds, natural justice and stuff. But having said that, my other point is, I don't think we should make too much out of the absence of competition appellate tribunal. I'll tell you why. It's just that we have not made use of it. Under Companies Act, the statute which establishes National Company Law Appellate Tribunal, the proviso actually talks about, the provision and a proviso talks about how the chairperson of the National Company Law Appellate Tribunal can set up a specialized bench to hear only competition matters. Now, if the chairperson of NCLAT today, Justice Bhushan, has not decided to set up a special bench which will hear only competition matters, we can't blame the statute. I mean, frankly, Parliament has enabled that. We should blame all of these human resources who are sitting in these tribunals and courts, right? And therefore, I wouldn't really, personally, I don't make too much out of the absence of competition appellate tribunal, though I know the reason why it got disbanded, and those are political set of reasons. But still, I mean, regardless of those problems, I mean, I don't personally see too much of a loss in terms of appellate tribunal, because the statute enables a specialized bench. Now, the statute also goes ahead under Companies Act again, and I suppose competition lawyers don't read Companies Act for some reason. I'm not sure why they don't read Companies Act, but Companies Act again talks about how you can, along with a judicial member, each of these benches can have a technical member. Just like Competition Act, there is a possibility of expertise. Again, I mean, why blame the statute when the blame really lies with the government, where they are not appointing people with experts? But that's a problem which is not confined to appellate tribunal. They also don't appoint experts at the competition. But as Amber would say, at least we are having this debate. I mean, at least there are so many cases and people are not indifferent to it. We are so worked up about it that we are challenging it, we are talking about it, which means Competition Act has really taken off in India, right? And competition law is something that people talk about. But I think there is a point, Manjushri, that you have, and that comes to the Supreme Court, because there my comparator is slightly different. I think Supreme Court of India, for some reasons which are not clear to me, they are very keen about hearing insolvency and bankruptcy code matters. And I have nothing against the code. I mean, it's a great code. I mean, I read that too, several cases. Every week, there is a case under IBC. But there isn't really, I mean, if not every week, even in months, you don't see a Competition Act appeal being heard. Like one of those is DLF case, very old case, 2011, involves real estate buyers. I was training the Competition Commission staff just a month ago, the newcomers, some 32 of them. And I asked them, since it is not clear to me, do you know why Supreme Court is not hearing one of the oldest appeals under DLF? And they had no clue either. So, I mean, if I have a grudge, I would say, I'm not sure what is it that inhibits or hobbles the Supreme Court of India to hear the competition appeals as well as they hear the insolvency and bankruptcy code appeals. And that's where I think I'll draw the line in terms of, I do have a grudge, but not with the CCI and the appeal tribunal. I think the blame lies with partly Supreme Court and partly government, who doesn't even appoint people with expertise.
Yeah, and actually it's very interesting because the other side of the story also sort of when we have the chance to interact with the ministries or regulators, what we're also sort of told is that there aren't too many people applying for such positions as well. So because, and this perhaps ties to what Amber was saying, in that competition is ultimately a culture. You ensure that people understand what the law tries to do, but there is lack of awareness regarding what the law is entirely. Because I've seen some great economists who sort of transition into competition policy, and that is perhaps an easy switch. But if that's not happening for some reason, then perhaps we do have a mile to go in terms of what advocacy measures that we want to take as a country. So let's move to digital markets now, because that's seemingly what India is debating currently in terms of how do we really regulate our digital markets in a way that it remains fair, contestable, and open for businesses of all sizes. So, in the first question, Amber, because this ties in very closely with the theme of the book, what are some, geopolitical peculiarities that you think South Asia particularly has when we talk about digital markets? And because most established practices of digital markets regulation, even now as the Committee on Digital Competition Law is deliberating this at the with the Ministry of Corporate Affairs, seemingly a precedent that's always relied on is, how the EU has gone about with the DMA. But whether the DMA is going to be a success is something we have to yet wait and watch. So, but again, that's a second order problem once we adopt something that may resemble the DMA. But even to think about comparing ourselves to, what the European Union is going through, I think we have to be mindful about some economic and political realities that are very, very unique to South Asia. So what would you think those economic realities and political realities are, and how should we be responding to the need to regulate digital markets?
So it's a complex question. I'll try to keep it as simple as possible at this stage, because I think we're very much at the early stages of thinking about these laws in the South Asian context. I think, first of all, so it's a double sort of edged sword, if we can say. At the one hand, India and Pakistan, again, are taking a bigger sort of lead in this regard, because the other countries are sort of waiting and watching to see what happens. So I think whatever these two countries do is going to have an impact going forward. So the double edge is, at the one hand, you want the investment that the digital economy represents. And of course, the belief that a foreign investment is a direct conduit to development, which is a contested belief. I think that is something we can talk about at another stage. But for now, let's stay with that. I think there's this view that, if you have foreign direct investment, you'll automatically grow and become better. The second, so in that sense, I think the digital platform is seen as bringing something into the countries. But the other side of the coin is the privacy implications of these platforms. And in that sense, they're extracting something from South Asia, which is, the language that we have in all our competition law discussions now is that data is the new money. Data is the new oil. Data is the new price. Whatever you place, data is gold. So what we're really giving up is data. So I think that any competition policy that we think about must also be in the context of a strong privacy policy at the same time. So whilst we want to encourage digital platforms to come in, and we want to increase foreign trade because that's going to be looking more and more like digital trade in the future. I think India is already one of the top 10 countries when it comes to digital trading, B2B and B2C in both markets. So I think it's an unavoidable reality. But what we need to see is that in the desire to attract this foreign investment, we don't become blind to its implications for our digital privacy. And by that, I don't mean personal privacy. I think it really is that collective, aggregated, even anonymized data that is a great source of power. And can have very strong implications for the future of the region, as a whole, and of course, the relationships of the countries inter se. What I'm seeing in Pakistan right now is a similar tussle. I think the need to attract, and I think I even mentioned that in the book in chapter 9, that the need to attract investment is actually, they want to just take a soft approach towards digital intervention. India, I think, is not taking a soft approach. I think India is mindful of its sort of potential as a great source of data, just like it has been a great source of raw materials for a lot of traditional industries in the past. So I think it's more aware of the role it's playing. But can it just borrow from the EU without adaptation? I would say, once again, it would be a big no. Because India is at a different point of its development curve than the EU. So I think it will have to strike its own balance in light of its own policies. My worry is that I think all South Asian countries are showing a very sort of, a trend, the sort of globalization and the international networking has only gained more importance in South Asia in recent years, because India was the one country that was holding its own for a very long time in terms of, we are not saying whether that was good or bad. We're just making an observation that for a very long period of India's history, India sort of set itself apart economically and didn't want to be networked into the global economy. But now that it is increasingly, from 1992 onwards, increasingly networked in the global economy, increasingly interested in working with the WTO, I think this is going to be a very delicate balance to strike. And let's see if the competition discussion is going to be equally bolstered by a discussion on privacy and data protection as well. Which, if you think about EU, please notice that they did the GDPR long before they reined in the platforms. And we are going in the other direction. We're trying to work on the platforms before we bring in a privacy regime. So yeah, I think not that I expect India to ever do blind borrowing. I think they will form a committee, which they've formed, and they will study. But I think it will be guided, as Rahul has been pointing out, the political motivations will be a very important factor in where the balance is struck.
And to sort of come back to you, Rahul, on something that Amber just mentioned, we just spoke about how when we look at privacy or access to data, we're no longer talking about it at an individual level, but in terms of what it would mean for us globally if India were to ever have a lot of its citizens' aggregated data with, say, somebody else. To that extent, because whenever there is a question on how should competition law deal with privacy, I don't seem to ever have a straight answer, because I do believe that some fundamentals about privacy at an individual level is best left to a data protection law and not necessarily competition law. And this is, again, a very, very formative opinion, but not necessarily a fully formed one. But Rahul, what do you think? Do you think in terms of what power that comes with large amounts of aggregated data, does privacy at a national level become a competition concern?
Okay, I think this data questions probably take us back to where we had started from, that World Trade Organization issue, right? And although we located for the purpose of this debate at WTO, but I'm sure Amber will know this, by the way. Way back in 1948, when none of us were there, when the world was debating International Trade Organization, the ITO, right? One of the chapters under ITO was restrictive trade practices. Now, unfortunately, in 1948, the ITO didn't see the light of the day. Again, political set of reasons, we don't get into it. But this is not really a new debate. Now, if you try and see, if we put the data privacy at WTO, it might make a very different sense from the perspective that we are debating about. Like, we are trying to locate data privacy in a national context. What economists call the drawbridges, right? Which is essentially we are drawing the bridge at national level. But think about it. Why should my data belong to government? Like if we are able to draw a bridge at national level, effectively you are saying that individual data, the property entitlements to those data belong to the government. Why is that acceptable? Right? So whenever people debate about it, it seems like the starting point is that somehow it is acceptable that it belongs to the government, right? Your Aadhaar data or every other ID that you have. Somehow we are okay if government has it, but we are not okay if probably maybe a multinational corporation or a global agency has it, even though that multinational corporation probably has a far better control than government will ever even think about. Right? So therefore, I suppose you see, Amber already pointed this out. This is a complex question. There are no easy answer. But I think our starting point should be, who does it belong to? Imagining data to be the new oil. See, oil is easier to understand because oil is below the ground. An individual doesn't have a capacity to drill. So somebody who has resources drills it, right? And therefore the person who has resources drills it, somehow owns it. And the person who owns the land gets a part of that cut. If individuals, even if we take the analogy that data is the new oil, if let's say as an individual I own some data, is government going to pay me for taking my data? Very unlikely, by the way. Highly unlikely scenario. So regardless of where the problem fits, whether it is competition law or maybe data privacy, I think we will have to rethink this entire issue in a very different context. And to me, that answer seems to be the World Trade Organization. Now, unfortunately, it's at a standstill. There is no appellate body. I think government of India, whatever good offices it has with US and other countries, maybe G20, they should, while they are debating crypto, which finds its way in newspapers, and that's how we see it, while they are debating crypto and what they should do to crypto and blockchain, maybe 5 minutes they should also devote on, should World Trade Organization deal with data privacy, data protection issues, And that could be possibly a better solution for citizens, frankly. And it might not necessarily be a great idea that these data just sits with governments and government exercise some ownership rights over them. And that's what I would say, that now maybe there is a need to think about it differently. And if I can again borrow from Amber's book, and this is very clearly, you can see it from the perspective of compatibility and legitimacy, right? Like, where is it more compatible? If I own my data, is it more compatible with national law or international law? And if there is going to be legitimacy, which is more like a moral concept, acceptance and all, right? Would it be better if national governments own them or World Trade Organization regulates them? And I think in that sense, the rubric is very clearly futuristic, which I said at the beginning of this talk. Right? That's all I'll say on the data. Thank you.
All right. Thank you so much, Rahul. But before the final set of questions, just a reminder to our audience, if you do have any questions, please do put it in the Q&A box. We've already received a few and some during registrations as well. So subject to time, we will try and go through all. So last set of questions to both the panelists. I think we've gone about a fair few things and seemingly come back to a few central themes, and that's never a bad thing, I hope, with discussions like this. So one final question actually to you, Rahul. When we sort of started understanding, when we started, interpreting competition law much after, the commission became functional, etc. I think worldwide and in India, there's definitely been an emphasis on a consumer welfare standard when we try and look at, harm that is construed in a market. Now, yes, globally, there's been some pushback on whether this consumer welfare standard is enough to, gauge effectiveness when it comes to digital markets. But I just want you to talk a little about whether consumer welfare was the only standard that India ever tried to pursue, because consumer welfare can often be a proxy for market welfare, but that may not always be the case. There are other participants in the market as well. So is this, if at all we are to also shift away from a consumer welfare approach, what I would like to understand is that, is this going to be a shift so much, or is this always been the path we were already on, and that we already recognize that consumer perhaps is not the only stakeholder in the market, and there's a need to look at something slightly broader? Where do you think India lies with respect to this?
So I'll again borrow from Amber's thoughts and the book, by the way. I think she mentioned it here as well. Yeah. That while we take from other jurisdictions, we must not just adopt them blindly. But in fact, what she said in this talk as well is adapt them to our local circumstance. And why am I saying that is because, you see, when we talk about consumer welfare standard, right, let's take the US context, because that's where the standard arose, right? What do Americans mean by consumer welfare? I mean, they're talking about by and large. And so when people talk about consumer welfare, in most contexts, they have end user consumer in mind. Right? Yeah, that's what they have in mind. Now, I mean, I think the drafters of Indian Competition Act, and we should give them a lot of credit, frankly, right in 2002, they deviated from the standard. The term consumer has been defined to include intermediate consumer as well, not just end user consumer. And therefore, the purpose of Indian competition law was never end user consumer welfare. It's just that what happens is that most competition law scholars are reading the EU literature, because that's easier to read, frankly, because EU very helpfully binds in a book and publishes the guidelines, right? Now, Americans are not so helpful. Their law is spread over thousands of case laws, which nobody wants to read outside of the US. So for us in India, we start thinking that consumer welfare, because EU is talking about, therefore, let's talk about some new standard called consumer welfare. Like for me, the Indian law is way more advanced because we did not copy blindly, as Amber said. And what we did was we adapted the law to our reality. So I think we should have a sense of pride that our law is way well advanced than Sherman Act, what the American courts have interpreted, what EU is doing, what UK is doing. But because we are former colonies, both Pakistan and India, we have this colonial tendency to think that we are somehow far behind, and therefore we should borrow from what the white people are doing. I mean, to me, it sounds like a very unacceptable sort of situation. I mean, I'm a proud Indian, proud South Asian. I don't see any need why we should think about the fact that British or the Americans have gotten it better than us.
All right, thanks a lot for that, Rahul. And Amber, sort of coming back to you again, and this sort of rings a lot of bells with what Amber and I were speaking a couple of days ago. In fact, just the importance of a competition policy, when we talk about diffusion and transfer, because often when the law is a limiting document because it cannot fully reflect the intention of the authors or the intention of why a particular law was passed for that matter, we often have something to rely or to go back on in terms of policy documents. And especially given that competition policy as a distinct tool is in use in many different parts of the world. What are your thoughts on the need for a competition policy in India? And do you think having a competition policy can help with some sort of diffusion and transfer to happen in a far more seamless fashion?
Yes, Manjushri, that's the question we'll end with. I just want to make a comment about what Rahul was saying because it really resonated with me. I think the issue that we have with competition law, which will lead us to talk about competition policy, is there is a colonial aspect to it, as Rahul has been, alluding to. He's saying that, oh, well, why should we borrow? I think the colonial aspect actually comes from a very different space also. I think when we became sovereign states, we wanted to work, we understood that the governments would work for the benefit of the citizens, which means everybody located within our borders, not say elsewhere, right? The consumer is actually not a citizen, doesn't have to be. The consumer can be anywhere. So the consumer of our product could be in the US. I mean, India is a great exporter of, many food items as well, which is, another area that I'm very interested in. So a lot of the food processing companies, the consumers are actually elsewhere. So when we talk about consumer welfare, the added dimension to it is that it may not be the same as citizen welfare. And that becomes a little bit of do we have the sovereignty to look after our citizens, or are we so tied into global economic relationships that we are actually more concerned about the intermediate processor who might be living in, housed in the EU, or the end consumer housed in the US? So I think that becomes a very tricky balance as well. So when we talk about consumer welfare as a standard, we really, whether it's the end consumer or the intermediate consumer, I think we are really looking at a denationalized, more diffused sort of, a buyer of our products and could be located anywhere. So that's, again, a balancing factor that governments will have to think about, because it's never a zero sum. You can't say, oh, well, I'll never think about consumers, I'm only going to think about. So I think the other important bit in this discussion is that a competition law, when it was generated, and Rahul very helpfully took us back to 1948, a lot of the competition conversations also started in that period. There was a need to diffuse or sort of loosen the stranglehold of national sovereignty. National sovereignty was going to be about social and political rights, that countries were sort of considered masters of their rights of their citizens, but the economic rights were globally interlinked. And the consumers could be anywhere. So I think there was a inherent balance in that. So that's why when we have WTO disputes as well, countries become very upset because they're like, well, this is not good for a state, but actually it's not looked at from a state perspective. It's looked at from the global perspective. This will be a thought that should guide us when we are thinking about privacy laws. It's a thought that should guide us when we're thinking about digital law, digital antitrust. But it's also a thought that guides us when we think about consumer welfare as a policy strand, as a competition policy strand. So that brings me then to the competition policy. So whilst we may not be able to do much with the competition law as it is created, because it is very much a law that is created to connect us to the global economy. The interesting thing when India adopted the law, and Rahul is very right to, and I totally agree, I've written it in my book that India spent a lot of time adapting it. One of the interesting things I noticed that the kernel of the law, the sort of core of the law, what are anti-competitive practices, that was the same as anywhere in the world. So they changed a lot of things around it, which made it easier to implement, but the heart stays the same. And there's a reason for that, because the law is created to network us into the global economy and which is why we adopt it only when the WTO tells us, or we adopt it after we have LPG policies in place So there's a reason, there's a method to the madness. But then what do? We can't do much with the law. The law is what it is. It enforces certain kind, it goes. What we then need is a more holistic imagination of what we want our economy to look like, and what other safeguards can be placed. So, for instance, if we are going to enter into a WTO, we are going to, have agribusiness in India or Pakistan, because the WTO wants us to liberalize agricultural trade. What are the safeguards we're going to put in place to protect our small agricultural producer, who is going to be, at the mercy of big agribusiness if the agribusiness is allowed a free hand? What are the laws what are the restrictions we're going to place on our big financial players? Are they going to be able to send, give loans to small industrialists on the same interest rates as to others? I mean, what will happen if they're if they cannot repay? So I think it has to be a more holistic imagination of what we want the economy to look like. And that's where the competition policy, I think, is very useful, because that can be implemented beyond a competition law. That can be implemented through a lot of instruments, policy instruments, a lot of legislative instruments, whether delegated legislation or statutory legislation. It can also guide the way courts interpret competition laws and enforce them. And I think that will then allow South Asian countries to use the competition law and the narrow niche in which it operates, but also to create, greater balance in the economies, and to use the competition law to bring up their own economies, rather than to support only the foreign business, which is by nature more efficient and more competitive, and therefore, giving a better price to consumers. So I hope that kind of captures it's quite a complex question, really.
Yeah, and no, that absolutely captures what I was sort of getting to, because the competition law sort of came in after we had regulated sectors. I don't think competition enforcement happens exclusively through the Competition Act. There are strands of competition principles that are weaved across, various regulatory instruments, and having a holistic competition policy gives us some sort of a sense in terms of how to stitch it all together. Absolutely, I do agree with you. And I think that brings us to the end of our discussion. We do have some question and answer sessions that we will try and keep it very brief. I will just open the question to both the panelists, and I'm happy to take both your views on it. So the first question is by Mr. Pranav Agarwal. It is evident that the economic reality of a country shapes its competition policy, both because of the nature of problems it faces and the private sector advocacy. Given the size of India's tech industry, with its array of homegrown tech giants, do you think that this industry has impacted in competition law? How does India's experience in this regard compare to other South Asian countries? Either Amber or Rahul.
I'm just reading the question again properly, given the size. So if I'll just begin this, and I think Rahul, you'll take it forward, because you obviously have more understanding of the Indian context. I think it's not so much, the question wouldn't be how the Indian industry has impacted competition law, but I think the opposite. How will Indian competition law affect India's nascent, or very, very well growing, I should say, not nascent, tech industry? And I think there also the question will be between nationalism and globalization, really. That's where the balance will be struck. What kind of, will India take a protectionist approach to its tech industry, and will it adopt policies that will foster its own national tech industry, or will it open up the tech space to international players and say, let the best man win, or whoever can do it better? And I think that again would be what I think the global economy will require, or suggest, I should say, use better words, would suggest that, persuade India to do. But I think India has a long history of safeguarding its national industries as well. So I'm sensing that some of that will continue. How does this compare with other South Asian countries? I would say certain countries most South Asian countries are very closed to international intervention. They're also so small that international platforms are not that interested in going into, for instance, Nepal. So Nepal doesn't have cross-border e-commerce. Bangladesh has some very little cross-border e-commerce. all of it is mostly B2C in all these South Asian countries. There's hardly any B2B, business to business e-commerce. I mean, India is really the biggest and perhaps the only player in this field. The second runner-up, not even a close runner-up, is Pakistan, and Alibaba has entered Pakistan. Daraz, which is a Pakistani platform, is operating in several South Asian countries, perhaps all South Asian countries, but they're one-offs. I think that these countries are very close to international commerce for now, and it looks like they're fostering their own e-commerce sectors, bringing them up to some level of sort of recognition before they open it up to the others. Rahul, you may have something to add to this.
Sure. No, thank you, Amber. There are two very important successful examples in the tech sector. And the two examples are firstly the UPI, the Unified Payment Interface, right? And the second one is RuPay, which has substituted with Visa and MasterCard. I'll start with the second one because this RuPay came about because of the Russia-Ukraine experience. Because when the war broke out, then they realized that if you have MasterCard or Visa payment, then it wasn't going through in Russia and Ukraine, it seems. And therefore, India decided to have its own interface when it comes to credit cards. So, and these two tech innovations, I think all of us use, if not RuPay as a card, we are probably using UPI anyway. Most Indians are using. And to that extent, one can see that the fact that there is a lower barrier to entry in the tech sector, India has tremendously benefited from it. And there are local players who are coming in, and they're probably also going to go global because some of these UPI is now available abroad as well. And similarly, my assumption is that RuPay will also scale up and go global as well. So in that sense, I think we can take heart from the fact that some Indian entities have benefited. I think the danger is that India becomes complacent. Like, we don't have the next Google, next Meta, next Apple. It's not there. I mean, frankly, I'm giving these successful examples to make sure that I also balance it out with the fact that we are not looking at next Google, Apple, or Meta, right? We don't even have the next Chat GPT. I mean, India graduates like millions of engineers every year, but for Chat GPT to come, we had to wait till the Americans thought about Chat GPT. And it looks like we have a long way to go when it comes to innovation, though it seems like there is some green shoots. And we can feel confident that because of this UPI and RuPay, India is also capable of innovating in the tech segment.
Absolutely. I think one really hopes that ONDC is going to go places, but here's hoping.
I skipped ONGC deliberately, but thank you.
Not at all, not at all. I mean, it's been a very favorite example of mine in the recent past, just to, demonstrate what sort of an approach we've had to, platform giants, and the ONDC does stand out, These are one of those things. Anyway, I'm just moving on to the next question. And as long as the other panelists don't have any other remarks, Amber and Rahul, we're done with the first question. Second, this is from Mr. Sudipto Banerjee, who's asking us, how do we make competition enforcement grounded in more data, basically grounded in surveys, primary data, qualitative or quantitative? How do we ensure that enforcement is more grounded in data? This is the question. Yeah.
Shall I go ahead, Amber? I mean, it looks like very...
Go ahead, and then I'll follow up with the more theoretical.
Quickly say that I think, so there are some parts of CCI analysis is already grounded in data. I mean, we should acknowledge that. And that we should acknowledge only because, you see, unlike the UK CMA, by the way, UK CMA has a statutory mandate to conduct market studies. India does not have a mandate, but it has some kind of an enabling provision that it can, if it wants to, engage in market. And we have seen that the Competition Commission has taken initiative in the telecom segment, right? Even in data and all. So they have conducted market studies, pharmaceuticals as well. So, I mean, the thing with data is that people tend to think about having a perfect data. Now, nobody will have a perfect data, right? And so good should not become enemy of the perfect. Right. So therefore, what CCI does is, at least, we should give credit to them. They engage in some market studies, and the limited data that they are able to collect, they try to action them through enforcement. Right. Now, that said, I mean, is the situation somehow, Panglossian, meaning everything is all good, hunky-dory? No, I mean, of course, we should engage with more evidence-based sort of research, figure out what is really going on in the sector. But it's a work in progress. And I think, to that extent, and to go back to what Amber was saying, I mean, and this is something which for me was a good takeaway, that sometimes we underestimate what CCI is doing because we are here in India, right? And the fact that, several stakeholders are engaging with market studies report, and there are multiple cases which are going on, it means that the law is working. And that's something which should give all of us some hope that it can only become better from here. With that, I'll hand it over to Amber.
I just want to make two quick comments, entirely in agreement with Rahul, everything he said, but I'll also say that how do you encourage more data is also by using more data. So I think we as lawyers, or we as people who are commenting on competition law should is quite an imperative, but if we engage more with data, then of course data is talked about. I think a second point I want to highlight here, that it's not just data, it's also analysis. And what when I reviewed I really did read all these cases until 2 years ago. I think there was this every Indian case on antitrust, which is abusive dominance position and anti-competitive agreements, and all the Pakistani cases, which were much fewer. I read all of them. What was striking is that they lacked economic analysis. So they were still being, we have to understand that competition is very light as a law. What gives it substance is its economic analysis, and it allows it to keep it flexible as well, and to be applied to diverse situations. What we are seeing, and I think I totally agree with Rahul that it's a work in progress. It takes time to come up to that point where, even the EU law was much more formalistic until 20 years ago, and now is more economics oriented. So I think we are in that phase where we haven't quite graduated to the economic analysis. So we are still applying competition law as a set of rules rather than, recognizing its ability to be flexible to different economic situations. So I think we'll start with data, but we really need to move to data analysis and competition and economic analysis of data.
Thank you for that, Amber. Thank you, Rahul. We just have one question that remains. Two, actually. Let's just move through it quickly. The first one is by Mr. Mahesh, who's asking us, one, what stage of economic development should a country adopt or introduce a competition law? Second, what has been the specific benefits that adopting a competition law has had to India? I think we've answered a large part of the second question, but the first question, if you can sort of shed some light on.
So I'll quickly begin this, Rahul, and please share your views as well. So I'll say this is an excellent question. I think it's a question we don't often ask. Is competition law appropriate for every country at every stage of development? The reason we don't ask this question enough is because we don't have the liberty to ask this question. I think the people who originated competition laws in the in the US, where it started with the Sherman Act in 1890, or EU after post-World War II, when they really, codified it as the Treaty of Rome, they had the liberty to ask these questions, but by then they had certain economic development as well. We are recipients of competition law because we are networked, as I said earlier as well, we are networked in the global economy. We are often adopting these laws. I think, it really does make you stop and wonder why a country like Afghanistan would have a draft competition law. Really, did they need that as their first law possible? Almost the first law right after a constitution? No, but they have it because it was, the DFID and USAID wanted them to have it. And that's why Bhutan has it. All the trainings that are conducted in Bhutan is with USAID. Bangladesh has it because WTO tells it. Pakistan has it because, WTO told them. India was a little bit smarter, but also Sri Lanka has it because US donors were insisting that you must have this law. Nepal also, the WTO was working very closely. I mean, I was very struck by the fact that the king was giving up his government, I think, within a day. So he was giving it 1 day later, 14th February, he enacts the law, 15th February, the government is done. How important was it to bring in this law? We saw the same in Pakistan. General Musharraf introduced the law literally 5 days before he, has the National Reconciliation Ordinance with the opposition. So we have to understand that this law is coming from a different space. So whilst the question is excellent, and absolutely the right question, which every country should ask, the liberty to ask that question is denied to a lot of us countries we are not thinking of the law ourselves. It is not coming from a space of, indigenous demand. It is coming from a space of foreign, requirement that we must have these laws. Having said that, all economies can benefit from a level playing field. So a competition law is not bad because it creates efficiency. So I will leave with that. I'll leave to Rahul, because I think we're getting into the conversation about national champions and all of that, which I don't want to get into, but maybe Rahul can shed some light on that.
I think you have already said everything that needs to be said. I'll actually, what I'll do is I'll sort of deflect the question inward and ask a slightly different question with a liberty to ask that question, which is, let's say, why is Indian competition law national? Why don't states have competition laws? Right? And I think because, if we talk about low income, high income, middle income, you can look at the states, right? Delhi is high income, Maharashtra is high income. Then there'll be states like maybe Assam and Odisha, low income. Why is it that states don't have these competition laws? And if we ask that question, which we can legitimately ask, I suppose, one could think of reasons why some states do need competition laws. Like I stay in Karnataka, Bangalore, and it's a fourth in terms of ordinal ranking, right? Karnataka ranks 4 amongst all the states, get a lot of foreign direct investment. It engages in a lot of public procurement. And one can see a need why a state like Karnataka or Maharashtra or Delhi might need a competition law, because it has something to do with level playing field, efficiency, consumer welfare, as understood under Indian Competition Act, including intermediate consumer. And therefore, one can see a reason behind it. But if somebody goes to maybe Odisha and Assam and says, you must also have competition law, I can see what Amber is saying, that it might not be the best idea to think about competition law as one of those laws at the stage of development they are in. That leaves only the middle income countries. And I suppose in some senses of the term, they can choose which side they want to. If they're aspirational, maybe they can get a competition law early on. But if they don't aspire to be a high income state, maybe they are okay not having a competition law. Right? Thank you.
If I can quickly jump in, Manjushri, because Rahul has made such an important point. And I think when we borrow from the EU, why don't we also notice in all the wonderful borrowing that we do from the EU, that every EU member state has its own competition law, which it applies within its national borders according to its national exigencies. If that argument, India is bigger than Europe, if that argument is brought to India, then yes, the states can also have their own competition laws, and there can be a federal competition law which looks at interstate trade, because as Rahul and I both know, that all competition laws are introduced through the interstate trade provision rather than through a direct competition provision in the Constitution. So yeah, these are big. I think the one takeaway from this discussion should be that what I've tried to do in my book is only scrape the surface of this conversation, and there's so much more to talk about here.
Yes. We just have one final question, and I don't think this is peculiar to patent laws. The question reads, do you see patent law coming against competition law, especially in pharma? But this is perhaps a slightly larger conversation. How do we really go about looking at competition enforcement vis-a-vis sectoral or other conflicting laws? So this is a question specific to patent in pharma, and I'm happy to take both your views on this.
Sure. Please go ahead.
Go ahead.
No, please go ahead.
Okay, so I'll just frame this question slightly differently for myself, as both Rahul and I have been taking the liberty to do. What I see is the tussle between IP rights and competition law. That's a very genuine tussle which exists because IP rights give you a carve out of competition. So for instance, you can say, okay, for a certain limited period of time, my IP right is protected, and it doesn't have to be, I don't have to be open to competition. And the reason for that is because one very important aspect of consumer welfare itself is also innovation. And, the idea is that the more you innovate, the better products you will have, and more, would be better for the consumers in the long run. So in that sense, I think IP and so there's always tension between IP and competition law, but it's a positive tension. It is geared towards creating more product. Pharma is particularly, I think we've seen in the COVID, very recent, when we went through the pandemic, that if pharmaceutical industry did not have the protection against competition laws, maybe these COVID vaccines would not have been developed. Having said that, do I think pharma is always right? Are they always using these restrictions in the best possible way? Not really. I mean, so I think then, that becomes then the question of when should these rights be retired? When should the generic drugs be allowed? And those are bigger conversations which are outside the ambit of this particular conversation. But yes, the tension is there in the pharma industry, and for a good reason.
Yeah. Rahul?
Yeah, so I think just by way of supplement, I fully agree with what Amber just mentioned. In fact, I will plug in her book over here, which is in fact in chapter 9, which also deals with the e-commerce segment. There is a significant part of the chapter where it also asks the reader to think about the goals of competition, right? And says that, essentially, if you are thinking about future solutions to problems, what is the purpose that your competition law has? And perhaps, different jurisdictions quite legitimately can have different purposes, right? Now here, when we talk about pharma, for instance, right? So we think that sometimes there is a tension, and as Amber rightly mentioned, the goals might be similar in some contexts, which would be innovation, and pandemic is a great example to see why a society might want to encourage some cooperation and might not be so worried about the tension between patent law and competition law. So I think, and this is the reason why, and to go back to where we had started, one of the points which Amber made was the institutions and the importance of institutions, right? Why is it that we have, let's say, a competition agency which is supposed to be specialized in each of these jurisdictions, right? Where all these countries, regardless of whichever stage of development they are in, the moment they are thinking of competition law, they think of a specialized agency, because we believe that these agencies will be alive to changing needs of the society. A pandemic, which is exceptional, will hopefully allow, I suppose, the leeway to the competition agencies to think that, certain goals of competition law might not be pertinent while pandemic is going on. And therefore, you may want to allow them to cooperate with each other or let a vaccine come in. And that's possible only because by choice and by accident as well, I suppose, because maybe US decided in 1890 that let's have an agency, perhaps, right? Similarly, you took the same route, and therefore we are in a situation where now it's an acceptable way to think about competition issues, that you have a specialized agency. And therefore, my point is that, you see, sometimes it may appear to be in tension, but the moment you have an expertise with the agency, the tension might not really be actionable, in the sense that might not be a real tension. It's an ostensible tension between the two statutes. And therefore, we must trust our design, which is that if so long as we have experts sitting over there, they will be able to respond to the changing fact situation. Yeah. Thank you.
And just a small data point to add to that, and this might be a little outdated, but at least my understanding of the kind of pharma cases that the CCI has largely looked at have to deal with cartelization at the trade union level, because these are largely hub and spoke cartels, and where members were in the guise of a trade union trying to impose NOC and PIS, etc. So substantial challenges on the scope of pharma laws versus competition law is not something that India has debated as all that much in comparison to some of its other counterparts. Just
plus, Manjushri, there, if your concern is distribution, I think India has also, and maybe the other countries have similar system too, but India, some states in India, let's say Rajasthan, for instance, right, has also experimented with this so-called Jan Aushadhi Kendra, which is essentially state procurement of pharmaceuticals. And the state distributes it at very cheap prices. You have different models. One doesn't necessarily have to think about, when it comes to distribution and pricing, competition law is not necessarily the answer. The state governments are also showing us a way as to how do you ensure that there is some kind of an end consumer welfare associated with purchase of pharmaceutical drugs.
Yeah, all right. Again, thank you so much, Amber. Thank you so much, Rahul and Amber. This has been a fantastic read and a fantastic discussion just to talk about, what is it that we as South Asian competition lawyers can do towards creating a better holistic understanding of what competition law and policy means for us. Again, thank you for taking the time out to write this and thank you for reaching out to Vidhi for this discussion. It's been fantastic to have you, and Rahul, it's always a pleasure to speak to you, and thank you for taking the time out to join us.
Thank you.
Thank you very much. I mean, the pleasure is all mine. I couldn't have asked for a better, more engaged panel. I think we could have gone on for longer, but I think this has been a very fruitful discussion. So thank you very much.
Thank you, Amber. Thank you, Rahul. Bye. And Atul and Preeti, thank you so much for the interpretations. See you all this week going ahead. Thank you. See you.